Under the Taxpayer Bill of Rights, Congress gave you a right to a collection due process hearing. It's sometimes called a CDP hearing. Your rights to a CDP hearing are limited, but though limited, that right is extremely valuable. This video will summarize what a CDP hearing is, who is eligible, how to request a CDP hearing, if you can appeal the IRS decision, and what it means to you.
A collections due process hearing is normally your best opportunity to resolve your tax debt through negotiations or settlement with the IRS. Generally, you can challenge the underlying tax liability, that is, whether you owe the money, only if you've never had an opportunity to test that liability previously. However, if you've had a chance to test it, even through a missed opportunity, you can't challenge the underlying tax liability. For example, if you've received a statutory notice of deficiency and you did not appeal it to the tax court, you normally cannot challenge this through a collections due process hearing. Instead, you must only address the issue of collection. A challenge to the underlying tax liability is extremely rare. Typically, there are only 2 or 3 circumstances in which you can challenge that liability. The first most common is an innocent spouse. In that instance, the IRS is trying to claim that you are responsible for your spouse's tax debt. The second is injured spouse. There, the IRS is trying to reach your assets for your spouse's liability when you have filed a joint tax return and you had no liability separately. The third most common is a responsible person. In that circumstance, the IRS is trying to hold you responsible for a business entity's payroll tax responsibilities. They haven't paid them, and they're trying to collect from you. In those limited circumstances, you can challenge the underlying tax liability. Even if you cannot challenge the underlying tax liability, in most cases you can use a collections due process hearing to propose some form of a collection alternative. These alternatives include installment agreement, partial payment installment agreement, offer in compromise, or uncollectible status. To be eligible for a collections due process hearing, you must have received one of 4 types of notices. They are: 1, a final notice of intent to levy with notice of right to a due process hearing; 2, a notice of federal tax lien; 3, a notice of jeopardy levy; 4, a notice of state tax refund levy. Usually, you may have received multiple notices before you receive that final notice. However, you're only entitled to 1 hearing. In addition, you must not have missed an opportunity for a prior hearing, nor can you have had a prior hearing and lose. In addition that you must have received a particular type of notice, you must also be fully and completely compliant. That means that you must have filed all tax returns when due, and you must have made all tax payments when they became due. There is one exception to the compliance requirement. That is financial hardship. Even so, you must meet all other requirements, and you must prove that a levy would result in financial hardship. This exception is extremely rare, and it requires full and complete disclosure of your financial condition. Ordinarily, you request a due process hearing by filing a Form 12153. This form looks reasonably simple, but you should not take it lightly. You should complete this form stating your grounds or basis for the appeal. You should also include a copy of the notice that you're filing an appeal with. Alternatively, you can simply write a letter stating that you want an appeal and include a copy of the notice. In the event the IRS hearing officer denies your appeal and sustains collections action, you do have a right to appeal to the United States Tax Court. But that appeal is fraught with a number of pitfalls. These include a number of items. The first is you must have raised all issues before the hearing officer. If you don't raise it, you cannot appeal it. Second, you must not attempt to raise issues that you had raised in a prior hearing and had lost. Third, the review by the tax court is based only on the written record. Anything that you say at the hearing is not part of the record, and the tax court cannot review it. Fourth, the tax court only reviews the hearing officer's decision based upon an abuse of discretion standard. That means that if the hearing officer had some basis for his or her decision, then likely the tax court will sustain that decision. With these many pitfalls, it is extremely imperative that you fully document the factual basis for your collection alternative and that you provide a complete record of the hearing. These pitfalls can trap the unwary. In almost every case, you need professional help. Most lawyers would not and do not represent themselves. Should you? Alternatively, if you are not eligible for a CDP hearing as a matter of right, for any number of reasons, could have been that you missed the opportunity to file for, you could have had a prior hearing and lost, whatever the reason, if you have no right to a hearing as a matter of right, you may be eligible for an alternative. These include an equivalent hearing. You get the same hearing, you just cannot appeal it. Or you may be able to pursue a collections appeal program hearing, sometimes called a CAP hearing. However, in either an equivalent hearing or a CAP hearing, you have no right to appeal the tax officer's decision to the United States Tax Court. Thus, after an equivalent hearing or after a CAP hearing, you cannot challenge the hearing officer's decision regardless of how absurd it might be. As you can see, a timely collections due process hearing request is an extremely valuable right that Congress has given you under the Taxpayer Bill of Rights. Do not lose it by neglect. It almost never fails that once or twice every year, I have to give bad news to a taxpayer that he or she has lost their opportunity to appeal a collection action to the tax court, or they've lost their best opportunity to work out a collection plan with an alternative. You should never ignore a notice from the IRS, particularly a final notice of intent to levy or a notice of lien. Best advice? Contact us or other qualified professional for help. You can reach us at www.brittna.com.
Your right to a collection due process hearing, though limited, is extremely valuable. Do not lose this valuable right by neglect. Contact a qualified professional for help.